When it comes to punishment, children and adults are not treated the same. We have an adult system, and for over a century, we've had a separate system for punishing children under 18, or juveniles.
The first juvenile court was created in 1899 in Cook County, Illinois, and it was created out of a sense that we weren't getting it right with respect to children.
The goal of the juvenile justice system was to determine what was in the best interest of the juvenile offender and essentially provide necessary services and rehabilitation.
In most states, if you're charged with a crime below the age of 18, your case will go before a juvenile court. Compared with the adult criminal courts, the juvenile system is generally more forgiving.
Juvenile records are sealed, there are a lot of services provided, and the goal is rehabilitation. They want to rehabilitate the children and get them to a place where they are being productive members of society.
Even after the death penalty was reinstated, juveniles were rarely sent to death row. But in the 1980s and 90s, that changed.
The crime rate increased dramatically during the 1980s. It increased for adults and it increased for juveniles. The crime rate peaked in around 1993. But during this time, when crime was escalating, you have a lot of politicians saying, this has really gotten out of control.
Got about 6 years to turn this juvenile crime thing around, or our country is going to be living with chaos.
Particularly in the late 1980s and early 1990s, state legislatures felt compelled to make it easier to try children in the adult criminal justice system.
You couldn't run for dog catcher in many parts of the country if you didn't support the death penalty.
So as crime increased and more children were sent to adult courts, pressure mounted on juvenile courts to hand down harsher penalties.
And critics of the juvenile court said, we've got to do something about this. And they said the reason that juveniles are committing so many crimes is that we're too easy on them in the juvenile court.
This harsher treatment of juveniles didn't go unchallenged. In 1989, the Supreme Court took up the issue of whether executing a juvenile violated the Eighth Amendment. In a case called Stanford versus Kentucky, the court looked at whether a death sentence given to a 17-year-old constituted cruel and unusual punishment under the Eighth Amendment because juveniles tried in adult court receive harsher penalties than those tried in the juvenile system. And the court said no.
The court ruled that it did not violate the cruel and unusual punishment clause of the Eighth Amendment to execute those who were juveniles at the time of their offense.
Writing for the majority in a 5-4 decision, Justice Antonin Scalia argued that executing a juvenile did not violate the cruel and unusual punishment clause because too many states permitted it, so it couldn't be unusual.
The court, citing evolving standards of decency, looked around the country to see what the states were doing and found that there was not a national consensus against executing those who were juveniles.